Okay, the next item is E-1. Mr. City Attorney, would you please read the titles to agenda items E-1 through E-3 into the public record?
Yes, Mr. Mayor. These are ordinances on second reading, change of land use, conditional use, and site plan review. Item E-1 is an ordinance of the City Commission of Coral Gables, Florida, requesting an amendment to the future land use map of the City of Coral Gables Comprehensive Plan pursuant to small-scale amendment procedures, Section 163.3187 Florida statutes, from religious institutional to community services and facilities for a 2.6-acre parcel of land, commonly known as the University Baptist Church, legally described as all of Block 116, Coral Gables Country Club, Section Part 6, 624 Anastasia Avenue, Coral Gables, Florida, providing for severability, repealer, codification, and an effective date. Item E2 is an ordinance of the City Commission of Coral Gables, Florida, requesting conditional use review pursuant to Zoning Code Article 3, Development Review, Division 4, Conditional Uses, to permit the issuance of a City of Coral Gables Certificate of Use, hereinafter referenced as a Certificate of Use, for a student increase of the existing Somerset Grace Academy Charter School of Coral Gables from 110 students up to a maximum of 260. The issuance of an annual Certificate of Use shall be subject to compliance with all of the conditions contained and referenced herein on property designated Special Use S zoning district, legally described as all of Block 116, Coral Gables Country Club, Section Part 6, 624 Anastasia Avenue, Coral Gables, Florida, providing for severability, repealer, codification, and an effective date. Item E3 is an ordinance of the City Commission of Coral Gables, Florida, requesting site plan review to permit miscellaneous site improvements and to permit the issuance of a City of Coral Gables Certificate of Use, hereinafter referenced as a Certificate of Use, for a student increase of the existing Somerset Grace Academy Charter School of Coral Gables from 110 students up to a maximum of 260 students. The issuance of an annual Certificate of Use shall be subject to compliance with all of the conditions contained and referenced herein on property designated Special Use S zoning district, legally described as all of Block 116, Coral Gables Country Club, Section Part 6, 624 Anastasia Avenue, Coral Gables, Florida, providing for severability, repealer, codification, and an effective date.
Thank you. These items on the second reading are considered public hearings, and so we will be entertaining public input. For those, I have 5 cards. If anyone else plans to speak, please get your cards in now. For those who have given us their cards already, would you plan to address either items 1, 2, or 3? Would you please rise up, raise your right hand, and allow the city clerk to swear you in at this time?
Would you raise your right hand, please? Do you solemnly swear or affirm that statements you enter into the public record today will be the truth and nothing but the truth?
Thank you. City Manager, do you have a staff person that will address the ordinance?
Briefly, Eric Rio will address it, and then I think it may be appropriate for the council, the representing the parties, to speak before public comment.
That's fine.
Good morning. As you indicated, Mr. Mayor, on December, this was before the Commission on first reading. All 3 ordinances were passed unanimously 5-0. On January 10th, a request was made to continue the application by both the applicant as well as the neighbors. The intent was to work out the private settlement agreement. They have done that, and they will present that or those findings to you as a part of their presentation. As a part of that review, 2 changes were asked of staff. One of the issues that they were asked was to go from 3 to 2 dismissals on the property. If you remember, there was 3 dismissals. They asked staff to basically provide a recommendation. Our response was, obviously, we didn't have the data and the analysis completed because as a part of the review process, our traffic consultant looked at their data and analysis. So the other thing they suggested is we look at trying to channel traffic into the site off of Segovia. So those two things, what staff has done is provided an additional condition, which is in your commission memo, which basically allows for our traffic consultant, the city traffic consultant, to go out and do a review beginning of the school year, which is in 2/12, August 2/12, look at these two issues and provide data and analysis regarding these specific two issues. This is hardline data. It's not from a surrogate school, so it would actually be on-site analysis. The analysis is detailed in terms of the 6 items that they're going to look at. Typically, they'll record, they'll look at vehicles entering, exit, stacking, and the sort. Then they'll come up with a recommendation. And the way this is written is staff will administratively review that and make a determination whether they can go to the 2 dismissal or the channelization of the traffic. So that is what's suggested as an amendment to this ordinance. In addition, staff, which is typical between first and second reading, we met with the applicant. We also met with the church because this is a unique application. There's changes that were made to clarify the conditions, which are shown in underline and strikeout between first and second reading, and that's on Exhibit C in your packet. And also, as a result of the packet going out Friday, the church has some additional changes that they would like, and that's what I'd like to enter into the record that you have before you all. The city attorney and I had met with the church yesterday. We agree with those changes, and we recommend, as a part of your recommendation for approval, that you include those as well in the packet. Pretty much that's it. Staff continues to recommend approval of all 3 applications. I'd be happy to answer any questions you may have.
All right, why don't Ms. Russo and Mr. Gibbs, would you like to come forward and say what you'd like to say?
Good morning, Mr. Mayor, Commissioners. For the record, Laura Russo with offices at 2655 Lejeune Road. I'm here this morning representing Somerset, and I would like you to say that Mr. Gibbs and I have been working tirelessly since the holidays, but in particular since the last meeting here, and I am very happy to report that we have an agreement with the Neighborhood Association and that the school and the neighbors have worked together to try to make sure that the impact of the school on the neighborhood will be minimal, and I can tell you I think everybody is very happy with the outcome and the process, and it has been a very positive experience. And so we are looking forward for your approval of the items on the agenda, in particular the conditional use approval and the site plan approval with the conditions, and we've seen the conditions, some of them that have been modified at the church's request, and we're completely in agreement with those conditions, and we have no issues with them.
The attorney's conditions from that
we have no issues with the changes that have been made.
Great, thank you. Mr. Gibbs?
Yes, good morning. My name is Tucker Gibbs, and I represent the Biltmore Neighborhood Association and Carlos Carta, who is a neighbor of this site. And my law office is at 3835 Utopia Court in Coconut Grove. And we have, just to confirm, we have come to an agreement with the school, as we discussed at your 2 previous hearings on the application. But one issue we would like you to consider today addresses traffic in the area, and Mr. Reel addressed it briefly when he made his presentation. My clients in Somerset have agreed to the following request as a solution to my client's concern regarding the school's traffic operations. As you know, the city has recommended and the school has presented documents regarding a 3-shift morning drop-off and afternoon pickup. And Mr. Reel has created this new condition or amended condition that talks about a staff review of those 3 shift drop-off and pickup, and to maybe bring it down to 2. My clients would prefer to do it in the opposite way, and what we would do is require 2 shifts of students instead of 3 for the morning drop-off and afternoon pickup. And then if it is determined by the city's consultants, pursuant to the analysis that Mr. Reel spoke about, that the 2-shift program does not work, and by what we mean by not work is creating stacking and spillover into the adjacent streets, then the school would, at the beginning of the next school year, which would be but the 2013-2014 2012-2013 school year, the school would go back to the 3 shifts that they proposed initially. That would be what we would like. In addition, we would also require that all school-related traffic during drop-off and pickup must enter the property by right turn from Cardena Street via Segovia Avenue, and a right turn and then a right turn onto Cardena. And then when they exit the property, they would do a right turn only onto Cardena, and then a right turn onto Anastasia. What that would do is pull the traffic in from Segovia, bring it into the school, and have it exit onto Segovia and out. So there's a light on Anastasia and Segovia that would help, do that. And then further, that no school-related traffic would turn left from Cardena into Anastasia and turn left from Anastasia to Cardena. That literally keeps the traffic away from the residential community. And what we would like to have these done is done first. And then the traffic study that Mr. Reel talked about would still happen, and it would happen, I think, by October. I think it's October.
October 15th.
October 15th. And if it's found that this does not work, then we go to the 3. This deals with the issues we talked about at the last major public hearing when my clients talked about the issue of the long shifts and how much time it takes. Also, we'd like you all to adopt that, and I also wanted to say some things on the record, to state on the record that this settlement agreement is between the neighbors in Somerset. I want to confirm that there is an existing 1977 ordinance, which you all have heard plenty about, and we understand that the church is only interested in retaining their rights if Somerset leaves to do the things that they were allowed to do under that 1977 ordinance, and we have no objection to that, and I want to put that on the record. And I also want to place on the record that we'd like to ask this commission to allow us to place into the public record our settlement agreement along with the exhibits, and ask the city commission to direct the city clerk to keep that as a public record on file with the city of Coral Gables until such time that Somerset no longer exists or its successors no longer exist on that site.
So everything Mr. Gibbs said, you're in agreement with. Is that correct?
Yes, that is absolutely correct. Somerset is in agreement.
Yeah.
Including the traffic pattern. We leave that up to you. We've told them we know 3 works. We're okay with doing 2. We believe it works. So whatever option, we're prepared to work with the neighbors.
And I'd like to conclude by saying that people may not realize it, but my clients worked incredibly hard, even over their holiday. These are people who work for a living. They took a lot of time out of their days and nights to meet with me and meet with Ms. Russo and representatives of the school, and our many discussions were lively, but we're really pleased. I think this is a solution that not everybody is thrilled with or happy with, but that's the mark of a good compromise. So thank you all very much.
Thank you very much.
Thank you very much.
Before they leave, may I just ask?
Yes, ma'am.
I just want to clear the record for this one. Shortly after, actually the following day after the first hearing, it was Wednesday, December 14th, there was an article in the Miami Herald. And I kept the article, and I want to read a quote in the article because I'd like to get some sort of closure on this issue. Because I came away after reading the article somewhat uncomfortable, but at the same time I understood that on many instances reporters may misquote an individual or a group. But in this particular article, the principal for Somerset, Ms. Ruiz, and let me just read the article as it's paraphrased. The principal for Somerset, Suzette Ruiz, said that 260 isn't an ideal number and that the school still plans to go forward with an eventual expansion. This is an article in the paper. I'm
sure she was misquoted, but I think to make it perfectly clear, we have Ms. Suzette Reese here, who is the principal, and I'll have her address that the school is Somerset Grace Academy. Here, just state your name and address.
Okay. I'm Suzette Ruiz, for the records, principal of Somerset Academy in the Gables. Can you repeat what was the article?
Sure.
Can you show it to her? Actually, yes, because I was.
Well, I'm going to read it to you. I'm not going to give it to you there. The principal for Somerset, Suzette Ruiz, comma, said that 260 isn't an ideal number and that the school still plans to go forward with an eventual expansion, period.
No, and for the record, I have stated here that 260 was the number. That was the agreement that we had made with the neighbors. So that was obviously a misquote.
And you said that later on, that you went on to say that you know, positively, what you just confirmed, you said later in the article, but I just wanted to get this out.
Absolutely, and I'm glad that you did.
Okay.
Thank
All
you.
right, thank you.
And that 260 number is in our agreement. So no matter what anybody says, it's in our agreement, we can enforce it.
It's just to set the record straight.
I understand.
It's not meant to throw a curveball. It's to set the record straight.
Thank you both.
Thank you.
All right, now we'll open up the meeting for public testimony. I have 5 cards, starting with Felix Pardo.
Morning, Commissioners, Mayor.
Good morning.
Well, I'm glad to see that that Tucker has, through his clients, his association, have tried to provide as many controls and constructs on this application. The Roberta clause, things like that are key. But I want to see if I could just bring a couple things up to this Commission's interest. And that is that I don't think that you have been informed properly of the issue of the master plan. In other words, the comprehensive land use. Much has been said about the restrictions and the safeguarding of the citizens. And this Commission, I know, has the intent to make sure that this is done. Problem is that in the application itself, as far as the land use is concerned, you have to read that 2 pages where it says, in conjunction with the 44% reduction in students, Somerset is proffering a Roberta clause in association with the requested change in land use from religious institution to community service and facilities. The agreement, the additional letter that was proffered today by the planning director has to do about preserving the religious component of it. In other words, that they are able to do certain things such as expansions, etc., not for the school, but for the church. In other words, that there could be additional implementation of that. Why is this important? And I'll get to it, but I wanted to make sure that I didn't leave any details out. The first thing is that this Roberta clause is being put in there because it says, I quote, this Roberta clause to be implemented with a restrictive covenant shall provide that when the school use ceases to exist or the school abandons the property, the land use of the property shall revert to religious institution. Now the problem is that that's great from a zoning standpoint. You got zoning and you have the master plan. Now years ago there were no master plans in the state of Florida. That was a state legislature item. The master plan, as you may or may not know, is an overlay of the permissible uses if accepted by this commission or any future commission. Now why is that important? Because if you look at this, they are going from religious institution in the master plan, the land use, to community services and community services and facilities. Now what does that mean? Well, it means a lot. When you look at their application, but even more disturbing, you look at your staff's recommendation, 2-page recommendation for the change of the master plan, the land use. It says, number 1, under the comprehensive plan analysis, Somerset Gables, 2 pages, note. It says in here that as far as the policy is concerned, and the policy that the planning director is quoting is actually from the school board from the state of Florida. He quotes policies and objectives, not codes or requirements. In other words, it's a we'd love to have it list. Keep this in mind. He says in there, it is consistent with the goals The University Baptist Church property is consistent with the goals, policies, and objectives of the City of Coral Gables comprehensive plan. No, it is not. The comprehensive plan right now, that is a religious institution with auxiliary uses of education, not the other way around. That was adopted in 2009. You have a land use plan that clearly stated that when the land use was finally implemented and updated, that was religious. Now, you're on a slippery slope. Let me tell you what it is. If you look at that land use plan, all of you together, look at that land use plan with your planning director, and he could point out everything that's in purple in that plan. There are religious areas all over this city. In other words, these areas that are religious, which are fine because they're community-based, and which is great, their impact is very, very different than an impact of the school. Now, keep in mind that these areas that are around there, traditionally, before the master plan even came into effect, remember, we were planned in the mid-20s, when all these areas around the city were put into effect, please keep in mind that there was no land use ordinance or legislation in the state of Florida. Now, keep in mind, all these areas were always S uses, special uses. Those special uses were really working as zoning and land use at the same time. All those areas were put into areas that were specifically residential areas. R, so you'll have an S special, D duplex. S special, R residential. The reason that you have this from a land use standpoint is very important. Keep in mind, you change this land use in this one, then all of a sudden you're going to be changing it in other ones. You don't have to change the religious overlay that you have now. You do not have to amend this master plan for you to be able to place these restrictions that have already been entered between Somerset and the Homeowners Association's attorney. So it doesn't hurt the application. What it does is it provides a specific restriction. Now, I'd like you to understand also that in this recommendation from your staff, it says, in its comprehensive plan, the city has affirmatively committed itself to finding solutions to school overcrowding. It's not our place to do what the school board has to do, the state of Florida school board has to do. Now, the objectives, again, that are quoted there are substantial. So the city, according to this, is currently, to our knowledge, not working on any other solutions. But believe me, when this is approved, there are going to be applications for every single religious institution that is a special use anywhere in the city. So there will be more assaults on single-family residential communities. Keep that in mind. Now, if this special use or this master plan would go into a commercial area, you don't have to do anything at all, including the zoning change. Now, it is shown as a religious, not an educational system. In the recommendation, it says the city's comprehensive plan identifies University Baptist Church location as a logical one for an educational facility. Keep in mind that at one point, your planning director even said that the requested change in land use to community services and facilities is the perfect category. Not religious. We're talking about something that is so open that you have no clue. You could actually back out the religious facility in the future once this is done, if you go from the religious to the recommended change of the master plan.
Mr. Pardo?
Yes.
At the last commission meeting, when we deferred this item, because both the neighbors and the Somerset folks were not able to come to a closure, we actually actively discussed the fact that, and if I'm speaking out of turn, please say so.
Oh, we all agreed.
We all agreed that approving the land use is inappropriate. So I think your point that you're making this morning is like right on.
Okay. And I'm sorry to be redundant. I just want to make sure that, and Mr. Mayor, I really apologize. I want to just make sure that no one has spent this amount of time on this specific issue. And I think that this commission has been shortchanged as far as this explanation. And the reason that it's important is not only just this application, but when you look at the map, you will see how scary it is as far as all the single-family communities around this neighborhood, with the exception of only 2 religious institutions that are in in commercial or / apartment high-density areas.
Thank you very much.
Okay, and I just wanted to add one more thing.
Okay, sure.
Okay. Just keep in mind that these special uses, when you backtrack on the master plan, you will see that they will pop out at you, and the best interest of the surrounding neighborhoods is quoted right in your code. And also, please keep in mind that when you look at your zoning map, the original zoning map, there are restrictions there under the plates, of the old plates, and it says specifically church purposes and child development center. And in closing, when you look at the master plan, you should definitely look at amending and taking out, without a doubt, one thing which is extremely, extremely dangerous, and that is this specific land use category that does not exist, the one they want to change it to, does not exist anywhere in the city of Coral Gables. It is a dangerous precedent. It should be stricken as a category from the land use plan, and I think it would be a great service that this commission could provide to the citizens of Coral Gables by simply striking out that use that has never been used in the city before. Thank you.
Thank you very much. Very done. Paul Zamek.
Good morning, everyone. Paul Zamek, 1505 Ferdinand Street, Coral Gables. I want to thank everybody for being here today. I want to thank, first of all, the city staff for working so closely with both parties on this side. I can honestly tell you that when Laura and Tucker told you that they've been working tirelessly, it's an understatement. I want to thank Carlos Carta and Alex Montecon specifically for representing the DNA so well. We learned a lot about each other through this process. I think, as Tucker also said, that the sign of a good compromise is that everybody walks away, wanting more. But I think what stands before you is the product of, honestly, 2 years of work, not just a month's worth of work. From the position of the Somerset Gables Parents Association, which I'm the president of, we're very pleased with the settlement agreement. We think that it accomplishes what we set out to do, and that's provide another educational opportunity for the city, also at a reasonable size, which protects the neighbors. I think we heard a lot of things that didn't occur to us during this process, so we're happy to include them. And we continue to be open to the needs and desires and concerns of the neighbors. I ask that you approve the application as it stands before you, and know that we're committed to continuing to work with the neighbors. This doesn't go away after today. We're going to be there, and we're going to be neighbors long after this leaves you. So as the president of the Parents Association, that's my commitment to you, commitment to the city of Coral Gables, and also a commitment to the neighbors and the parents as well. As long as I will be involved in the process, you're going to have that level of commitment, and I'll be accountable for our parents abiding by this settlement agreement. So once again, thank you all, and I strongly urge you to approve the application. Thank you.
Thank you very much.
Thank you very much.
Albert Sanchez.
Good morning.
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 My name is Albert Sanchez. I live at 619 Camilo Avenue with my wife, 9-year-old son, and 5-year-old daughter. Over the last 2 years, much dust has been thrown around on the charter school issue. As the dust begins to settle, I think it's important to review where we're netting out. A 34-year-old restrictive covenant is being thwarted, and permission for a school enrollment that defies anyone's reasonable definition of a neighborhood school is being established. During this debate, I've often been asked what number I could live with. My response has always been the same. Given that this is being touted as a neighborhood school, 1 class per grade, K through 8, seemed like a reasonable solution to me. It's a model that serves many schools well, including the school that my own children attend. However, I always found the numbers question fairly presumptive because it assumes that there's a bona fide need for a school. A review of the facts very strongly questions that need. I think that school board member Raquel Regalado best addressed this issue when she presented before this commission last August. During her presentation, Ms. Regalado praised the city for the fact that every school in Coral Gables, elementary, middle, and high school was A-rated. So from a quality point of view, there is no need. Addressing the capacity issue, I'm sure you recall that Board Member Regalado stated that numerous schools in Coral Gables and its surrounding areas were under-enrolled, including Henry West Lab, Sunset Elementary, David Fairchild, and Ponce Middle. Therefore, from a capacity standpoint, there is no need for an additional school. Yet there are supposedly hundreds of students on the charter school's waiting list. Over the course of many different meetings and hearings, it became quite evident to me that this school was not appealing to children in our local public schools, but rather children in private schools. Parents whose children had attended or were attending schools like St. Philip's, Gulliver, and St. Teresa took this podium to argue about the need for an additional school option. And now we have that additional school option, one that caters to parents who would otherwise be sending their children to private school. Hardly the type of school option that I think many envisioned. When I walk over to the Coral Gables Library and vote in city elections, one of the underlying tenets for any candidate that desires to be a public official is leadership. I've been happy to see that this commission, either collectively or individually, has provided leadership on a host of issues. Unfortunately, this has not been one of those times. With the exception of Commissioner Anderson, this commission has demonstrated a conspicuous lack of leadership on this issue. Requesting that a neighborhood association and a huge school conglomerate come to an agreement is not leadership. Rubber stamping that agreement without much debate is not leadership. This is a major public policy issue, not simply a neighborhood issue to be worked out behind closed doors. This is an issue that affects all of Coral Gables far into the future. I have yet to find a neighborhood association on the Coral Gables ballot. Rather, it is each of you whom I have seen, and it is for you for whom I have voted. I ask you to demonstrate the leadership commensurate with your position and debate this issue today and vote for what you honestly believe is the right course for Coral Gables. Thank you.
Thank you. Sandra Morava.
Speech.
Good morning, Commission, City Attorney, City Clerk. My name is Sandra Murata. I'm a resident and a business owner in Coral Gables. I'm just here to raise 2 points. One of them goes back to a discussion that was on the record during the March 23rd, 2010 Commission hearing. And I'd like to raise something that I thought was a valid point, and I have a question. So one's a question and one's a comment. Commissioner Kurdike raised a very, very valid and vital point during the preliminary discussions before Somerset had made any sort of application before the city. And that was, what are the physical education requirements of a charter school? My daughter attends Coral Gables, now known as Preparatory Academy. She's a third grade student. She has physical education every day. I ask myself, what are the physical education requirements for a charter school? I don't know what they are, but I know that I'm paying for it. I'm a taxpayer. I'm a voting taxpayer. So my question is, Commissioner Kurdike, did anyone answer that question? Did anyone look into this? Does anyone know the answer? Because frankly, I don't know where they're going to do physical education. I hope it's not at the youth center, because the Parks and Recreation Board, as you all know, unanimously passed in their minutes opposition to this school being there, a change in the land use, and everything that had to do with this. But you all know that because you approved these minutes just a couple months ago. So if you could, I'd like the answer, if any of you have that, because I think it's a legitimate answer. And the second thing I'd like to raise, and I'd like it to be from somebody who has authority, perhaps from the school board, because I don't know what the answer is. And when I've asked, I haven't been given an answer forthright. And here's the second thing I'd like to raise before I sit down. in the capacity that all of you are sitting in now as a commission, with this issue before you, with this application before you, with a proposed agreement before you that you are about to vote for and pass or not pass. My question is, this is a quasi-judicial proceeding, which means that the public is limited to the conversations they may have with their elected officials. Lobbyists, who are hired guns in my eyes, are the ones that are allowed to sit and discuss issues with you. In light of that, I've been involved in this matter since it happened 2 years ago, and I won't go why, because I'm not an affected neighbor, but I do believe in integrity of the process, and I do believe in transparency, and if I didn't care, I wouldn't be here. So my question is, the city's position is very clear on the record, especially during the lawsuit that was filed in June 2010 before Judge Jennifer Bailey. I cannot secure a copy of that because now I'm prohibited from getting copies of a pleading unless I'm a judge or an attorney of record. So I'd like to know, or I'd like to raise, and I'm not a land use lawyer, but I'd like to raise a consistency challenge, because it is my opinion that the prior former city attorney who represented the views of this city and gave her recommendations and went to court before Judge Bailey, who ultimately ruled that 110 was the number, came back. And I'd like to know, then, what is your position, Mr. Lean? Have you had an opportunity to review this agreement? Is it legal? Will we see it? Or is everybody going to rubber stamp it? And if there is an inconsistency, then what in fact is the position of this city on this very application? Thank you.
Mr. Gibbs, you want to address the recreational issue?
I can address both of them because
Okay.
it's my agreement, not
All
the
right.
city's. The issue of the PE requirements, I don't know what the PE requirements are, but the issue was the youth center. In our agreement, as well as I believe in the conditions of the city, it specifically says that the schools agree, the school will not use the youth center. So that can be enforced by my clients, and it also can be enforced by you all as a city. You all are not being asked to bless our agreement. Our agreement, as I said before, is a private agreement between the neighbors and Somerset, and we had this discussion at a previous meeting. It has nothing to do with the city. In fact, some of our requirements are more stringent than the requirements of the cities. So just to put that on the record.
Okay.
Sorry for coming back, but my question wasn't answered. I'd like to know if anybody can give me an answer as to what the physical education requirements are for a charter school if you have an elementary school. And please don't mock me. I need to know because I'm paying for that school. And I want to know if there's going to be compliance with the law, because when this has been rammed down my throat, I want to know who's responsible to make sure that all the T's are crossed and all the I's are dotted. That's what this is about. I want to know if there's going to be compliance, period.
Does the principal of the school have any views on any information in terms of the PEs? And then we'll move on to the last.
Once again, the physical education requirements are the same compliance as any other traditional public school. We are bound by the same requirements. We have to be compliant in order for the school to operate, in order for the information to be given to the parents. And there is a charter school office that comes out to the schools that makes sure that we are in compliance with all of those rules, and we will continue to do so. We have benchmarks that have to be followed, standards that have to be followed, and there is a space available at the school to conduct the physical education classes.
Thank you very much.
Thank you.
Ana Louise Fulks.
Thank you.
Go ahead.
Good morning, Commissioners, Mr. Mayor, Mr. Lane. I am looking at a covenant and a restrictive ordinance that was signed many years ago on February 29th, 1968. This is directed basically to Mr. Lean. I would like you to go back to the very beginning to read what was signed and delivered by our City of Coral Gables and the University Baptist Church. This did not include any charter school or any other entity except a child development center at a religious institution. I think it states it very clearly. It's underscored on some parts of the paper that I have given you, that it shall be binding upon the said trustees, which is University Baptist Church, and their successors. Anyway, Mayor Dunn signed this, and it was also signed by Virginia Paul, who was the city clerk at the time. I now jump to the ordinance, which again goes directly to University Baptist Church. It does not go to Academica, Somerset Gables, or BNA. It states very clearly that said property for the operation of a child development center shall be subject to the following conditions and restrictions. Do you want me to read them, A, B, C, and D?
No, we have this.
All right. At any rate, what I am asking is that Mr. Lean go back to the beginning, look what was said, written, contract, binding by our City of Coral Gables and by University Baptist Church. BNA, UBC, Academica does not represent me nor many of my neighbors. Who does represent me are my elected officials who presently sit on this dais before me. Lastly, Marie Anderson, I wish you the most happiness in your future of the calling of the ministry, and I thank you for the so many years that you have sat before us with your sensitivity and your kindness in the rulings that you have done in the past. Good morning, ladies and gentlemen.
Thank you for your testimony. All right, that ends our public testimony part of this item. Mr. City Manager, you had a couple points that you wanted to make?
Yeah, Eric, would you just come forward? There was an issue raised, and I think staff would just like to provide some additional information for the Commission's consideration when they consider one of the suggestions made here this morning.
As I briefly outlined in my presentation, just a little background on the traffic. The applicant provided a traffic study to the city, an accumulation study. Our traffic consultant evaluated that data. That data was based upon a Serriott school. Similar situation, similar, location and whatnot. And that's what we formulated our conclusion for, and that's what they did the 3 dismissals on. The proposed language we're proposing is to allow actual data to be compiled on site, which is hardline data, traffic accumulation, traffic studies, level of service. For that reason, staff recommends that we start with the 3 dismissal, and then, depending on the data that's provided, we can then go to the 2, and that would be enacted on January 2013. So basically, when they start the school year, for about 45 days, our traffic consultant would look at the data. October 15th, they would give us the data to us. We'd make an administrative determination, and that would be issued or implemented, depending on what those findings are, in January. Staff recommends we do that because that provides us with evidence, hard facts, rather than just saying an assumption that we're going to 2, which has not been the case throughout the entire application review. So staff recommends we start with the 3, and then, depending on the information, go to the 2.
But Eric, wouldn't you study it at 2 and then get that data? I mean, I don't understand the
But by doing the 3, you get a worst-case scenario. You look at...
Yeah, but if you get 2 and you say it's going to work, then why go to 3? I mean, And if it doesn't work, then you go to 3. I mean, there's no alternative. You're not going to 5. I mean, it's either 2 or 3.
From staff's viewpoint, we feel more comfortable having substantial competent evidence to support the 3 to 2. And that's.
I mean, listen, I like to listen to staff, believe me, but the fact is I can't see the difference. I mean, and if the party agree upon 2 to 3, I mean, I just can't see the substantial difference between it. And the neighborhoods want 2 as opposed to 3, then let's stick with the agreement. That's my opinion. I don't see the rationale from going to 3 to 2. Okay.
Okay.
Thank you, though.
Thank you. Craig, do you have anything you want to say before we begin our discussion? Anything?
Well, there have been a number of statements related to the city attorney. I generally would answer them only, though. Sorry. There have been some statements made regarding legal interpretations of the prior city attorney of myself. Generally, I would just answer those questions from the commission if you have them. If you want me to speak on those issues, I will.
Please do.
Please.
Well, first, the lawsuit, which one of the residents brought up, it should be recognized that that lawsuit was over. The decision that the judge made in that lawsuit was on a limited issue of whether an injunction, a preliminary injunction, should be issued or not. And there, at least in my opinion, I'd look at the order that was issued. There was no final decision in that case, and I do not see that decision as standing for the proposition that only 110 students can be at Somerset. I don't think it says that at all. So I don't think that binds you in any way. On the second issue, on the issue of a restrictive, and I'd also say that in terms of being able to get pleadings or anything like that, if you make a request of the city attorney's office, we can certainly give you pleadings in the future in any matter that we're involved with, if that's what you'd like. Now, as to a matter of, and I don't have any control over the county clerk's office, so all I can do is control what's requested of the city attorney's office. Now, as to the declaration of restrictive covenant, I gave the opinion previously that I think it's important to recognize what this restrictive covenant was about. This restrictive covenant related to approval of a walkway, of a covered walkway. And as part of that, there were 2 provisions. One which said that said property will not be leased or rented or used in violation of any of the ordinances of the city of Coral Gables now in effect or hereinafter enacted. And the key provision there is hereinafter enacted. This was not, by its own terms, was not intended to be the end of everything in 1977. Pardon me, what year was this? 1968. It specifically said hereinafter enacted. If you enact these ordinances, then it would be consistent with ordinances, consistent with law, and in my opinion, you could do that. The second provision is it's standard language that relates to whenever you make, and we have this in other types of restrictive covenants as well, this covered walkway, basically this is saying you can't split the property because there's now a covered walkway that's being approved. I don't think that this, particularly where this is, in my opinion, it could be an accessory use to the church, I don't see how Provision 2 prevents you from acting in any way. Also, Provision 1 is the principal, in my opinion, provision here. And if there is a future ordinance that permits this with a number of conditions, then that future ordinance would control. So I do not see the restrictive, although you can consider the restrictive covenant, I do not see this as binding you in any way in terms of your ability to act today. Now, I've also been asked in previous meetings relating to the land use change, would the commission like me to talk about my legal opinion on that?
Yeah, because I think maybe the best way to do this would be to take up item E-1 and have your opinion and a discussion and a vote on that, and then move to 2 and 3 as a block, or we'll vote on them separately, but discussion on 2 and 3. So why don't you give us your opinion on E-1 on the land use change?
Well, there's a couple portions to my opinion. First, the current land use at the church is for religious institutional. And there's presently a charter school there. So presently, there's a charter school operating in a religious institutional land use category. And that's at that church. I did, at the last commission meeting, I was requested to look into a little bit what our practice is in Coral Gables relating to religious institutional land use. And city staff provided me with 11 different churches or religious institutions that have schools or some sort of educational use attached to them. And 10 of those were in a religious institutional land use category. The one that wasn't, which was brought up by Laura Russo last time, was St. Teresa. But remember, St. Teresa, first of all, is a much larger school. It's about, as I recall, it's close to 900 students, but it's much larger than what's being discussed here. In addition, it's a separate, the church part of St. Teresa is on a different block, and that is a religious institutional land use, as I recall. And then the school, which is a separate block, is educational. Now, the closest comparator that I found was St. Thomas. And St. Thomas is a religious institutional land use, and it has been approved for, according to the information provided to me by our zoning department, zoning office, for school from, pardon me, let me get the, I'm going to read it directly from the document. It's been approved in a certificate of use for 3-year through K, for 3-year-olds through kindergarten for 129 students, and for grades 1 through 6 for 196 students. So that's a total of 325, which is larger than what you're being asked to consider here as an accessory use, and that is a religious institutional land use. So certainly the practice of the city of Coral Gables, in my opinion, would permit you to follow precedent and continue to keep this as a religious institutional land use. In addition, it's my legal opinion that you do not have to, and based on, and I've stated before the rationale for it, but it's my legal opinion that you do not have to make this land use change in order to approve the zoning ordinance and the site plan ordinance. I can go into that further if you'd like, or answer any specific questions.
So what you're saying is we would deny this application if we didn't want to approve the land use. We deny item 1, E1. Is that correct?
No. My opinion is that you can do, yes. My opinion more completely, though, is that you can do either. It is within your, this is a legislative item, it is within your discretion. You can do either. Okay. But it would, if you deny the land use change, you can still approve the other 2 ordinances before you.
That's what I want to hear.
Okay. Thank you. All right, let's have any discussion on this. If not,
just one quick point. I think Mr. Pardo's testimony, I guess he left. Mr. Pardo's testimony earlier today, I mean, he was a member of the Planning and Zoning Board for quite a long time. To me, it was very convincing, and I think Mr. Gibbs's arguments at the last hearing were convincing as well. I just want to lay on the record, I will be voting against item E1.
Right. So, why don't we entertain a motion then to deny rather than the other way around? And do I have a motion on that?
I move it. I'll second it.
Okay, a motion made by Ralph Cabrera and seconded by the Vice Mayor. City Clerk.
Do we have an opportunity to
Commissioner.
Actually, I'd like to make a couple of comments.
Okay, yeah, go ahead.
Yeah. If personal opinion, if I could vote on my personal opinion, there would be a lot of different votes. But I can't do that in this arena. I'm called to look at the facts and put my personal feelings aside. I try to abide by all the standards, ethical standards that I'm guided by. And I'm not a big fan of charter schools. Not a particular reason. I don't care for them, but they are the law and they're allowed. I don't like the way this came about, but here we are. It still troubles me, but I think we've reached the best possible compromise. And Albert, Anna Louise, I'm sorry if I've let you down today. I'm going to be voting for that, and it's troubled me greatly, but I feel this is a compromise that I can live with. And it's never easy up here. And I appreciate your kind words, and I hope that I can still count on your kindness and your friendship. And that being said, I can move on.
Okay, so we have Commissioner Cabrera has made the motion, Vice Mayor seconded, City Clerk?
Vice Mayor Kurdike?
Yes.
Commissioner Casada?
Yes.
Commissioner Anderson?
Yes.
Commissioner Cabrera? Mayor Casey?
Yes. Okay, discussion
Clarify, that's a yes vote.
to deny.
Deny.
Deny the change of land use.
To deny it, yeah.
Yes or no? Okay. Items E2 and E3, do you want to discuss these together? I think they go together.
I'll make the motion.
Mr. Mayor, we would ask that you can discuss them together, certainly, but that you vote separately.
Right.
I'll go ahead and make the motion for E2, and I'll just make a quick comment. My comment is very similar to Commissioner Anderson's. The fact is that, 260 children, I don't know if that was going to be the number up here. I know I have some angst about it. But the fact is that there's a lot of other forces that weren't in play in 1977 in protection of the neighborhood. Making sure that's not 550 in 2 years is probably a big consideration of why this agreement is made. So at this point, I am, as I mentioned, I will make the motion to approve this, to move it from 110 up to 260. Yes.
Mayor? Mayor?
Yes.
Mr. Vice Mayor, just note, do you, based on your comments earlier, do you want to amend the ordinance, changing it from 3 to 2? Because you need to make that amendment.
Here? Okay.
Yes, in both E2 and E3.
Oh, E2, yeah.
But, Mr. Kurdike, also, as I'm prepared to second your motion, but I would like to entertain as an amendment to the motion to do what was required or requested, which is to include the settlement agreement as part of public record, which is something that I wanted to add to it, as well as the letter from Burkow, Riddell, and Fernandez as part of the agreement. Are you comfortable with that?
I am.
Okay.
I am too, yeah.
Mr. Mayor?
Yes.
Just to clarify, the conditions that we'd asked for is the traffic circulation, which included the right turns.
Yeah, right. That's
All the
all.
right turns,
Right.
if that can be included.
That would
and
be-
the settlement agreement to be recorded as a public record. And what you wanted to say is that the
city record.
Burkow-Radell letter would be recorded in the city's record as well, but not part of the settlement agreement.
No, these are separate. These are separate
And the
items.
settlement agreement will be part of the city's records.
The city's public record, yes.
Mr. City Clerk, do you have all that? That's good.
Yes, I do.
Yeah. Thank you so much. From 3 to 2.
From 3 to 2.
Right, 3 to 2. We're going to test 2 out.
And the right turn,
Right, and the right turn, yeah.
Everybody
Is there any questions,
clear on
Mr.
this?
City Clerk?
No.
Okay.
Okay, so we have
Thank
the
you.
Vice
Commissioner
Mayor's made a
Cabrera.
motion, Commissioner Cabrera has seconded it, City Clerk?
I would like to have some discussion prior to the vote. Mr. Sanchez brought up a point that's something that's been in the back of my mind throughout this process. When the school board member, Raquel Regalado, came before us, what was it, May, June? Was it August? At that August meeting, she went through the different public schools in Coral Gables, and she gave us an update. She let us know that they were all A schools, and she talked about the enrollment numbers. And that's something that when this process began, I went back to the minutes of that meeting, and I scanned through it. And she talked about some under-enrollment, some over-enrollment at the different schools. And if this number was going to be closer to the 400 number, or the 700 number, that was definitely going to be the main reason why I wasn't going to go that high. But because I think the numbers come down a significant amount, and I think that we're at 260, I think I'm okay with it at this point. But I just want to point out that it was a very good observation by Mr. Sanchez and the school board, and it's something that was always in the back of my mind. I'm glad it was brought forward in the public record.
Okay. That's it. Any more discussion on item E2? Not, City Clerk?
Commissioner Casada?
Yes.
Commissioner Anderson?
Yes.
Commissioner Cabrera?
Yes.
Vice Mayor Kurdike?
Yes.
Mayor Casey?
Yes. Item E3, the site plan review. Any discussion? Have a motion?
Pardon me, before the motion's made, the 2 to 3 probably should be part of the site plan, too.
Yeah, no, it's
Okay.
Sorry about that.
Yeah.
Both.
I'll make the motion with the same changes that we made in the prior motion.
I'll second.
Okay.
Okay. Motion's made by the Vice Mayor. Commissioner Cabrera has made the second. City Clerk?
Commissioner Anderson?
Yes.
Commissioner Cabrera? Yes. Vice Mayor Kurdike?
Yes.
Commissioner Casada?
Yes.
Mayor Kaysen?
Yes. If I could just commend both lawyers and both of the neighbors and the school for working out this agreement. I think it took a long time, but I think the extra 30 minutes was helpful in reaching a final conclusion, and it's always great to have a win-win. Even though everybody's not totally satisfied, I think this is good for the city, and I hope that you all will continue to work together and make this a smooth process over the next couple of years. Thank you.